So hi guys, I'm Lou and welcome to Lou's Green Life. And for today's video guys, we're talking about a libel. Well, that is crimes against honor, its definition, forms, and punishment of this crime. So without further ado, let's dive in. So guys, Article 353, definition of libel. So a libel is a public and malicious imputation of a crime or of a vice or defect, real or imaginary, or any act, omission, condition, status, or circumstance tending to cause dishonor, discredit, or contempt of a natural or juridical person, or to blacken the memory of the one who is dead. Article 354, Requirement of Publicity. Every defamatory imputation is presumed to be malicious, even if it be true, if no good intention and justifiable motive for making it is shown, except in the following cases. Number 1, a private communication made by any person to another in the performance of any legal, moral, or social duty. And number 2, a fair and true report made in good faith without any comments or remarks of any judicial, legislative, or other official proceedings which are not of confidential nature, or of any statement, report, or speech delivered in said proceedings, or of any other act performed by public officers in the exercise of their functions. Article 355, Libel by means of writings or similar means. A libel committed by means of writing, printing, lithography, engraving, radio, phonograph, painting, theatrical exhibition, cinematography, exhibition, or any similar means shall be punished by prison correctional in its minimum and medium periods, or a fine ranging from 200 to 6,000 pesos, or both, in addition to the civil action which may be brought by the offended party. Article 356, Threatening to publish and offer to present such publication for a compensation. The penalty of arrest to mayor or a fine of from 200 to 2,000 pesos, or both, shall be imposed upon any person who threatens another to publish a libel concerning him or the parents, spouse, child, or other members of the family, or the latter, or upon anyone who shall offer to prevent the publication of such libel for a compensation or money consideration. Article 357, Prohibited publication of acts referred to in the course of official proceedings. The penalty of arrest to mayor or a fine from 200 to 2,000 pesos, or both, shall be imposed upon any reporter, editor, or manager of a newspaper, daily, or magazine who shall publish facts connected with the private life of another and offensive to the honor, virtue, and reputation of the said person, even though said publication be made in connection with under the pretext that is necessary in the narration of any judicial or administrative proceedings wherein such facts have been mentioned. Article 358, Slander. Oral defamation shall be punished by arrest to mayor in its maximum period to prison correctional and its minimum period if it's so of a serious and insulting nature. Otherwise, the penalty shall be arrest to minor or a fine not exceeding 200 pesos. Article 359, Slander by deed. The penalty of arrest to mayor and its maximum period to prison correctional and its minimum period, or a fine ranging from 200 to 1,000 pesos shall be imposed upon any person who shall perform any act not included and punished in this title, which shall cast dishonor, discredit, or contempt upon another person. If said act is not of a serious nature, the penalty shall be a misdemeanor or a fine not exceeding 200 pesos. Section 2. General Provisions. Article 360. Persons responsible. Any person who shall publish, exhibit, or cause the publication or exhibition of any defamation in writing or by similar means shall be responsible for the same. The author or editor of the book or pamphlet or the editor of business manager of a daily newspaper, magazine, or serial publication shall be responsible for the defamation contained therein to the same extent as if he were the author thereof. The criminal and civil action for damages in cases of written defamation as provided for in this chapter shall be filed simultaneously or separately with the court of first instance of the province or city where the libelous article is printed and first published, or where any of the offended parties actually resides at the time of the commission of the offense. Provided, however, that where one of the offended party is a public officer whose office is in the city of Manila at the time of the commission of the offense, the action shall be filed in the court of the first instance of the city of Manila or of the city of province where the libelous article is printed and first published, and in case such public officer does not hold office in the city of Manila, the action shall be filed in the court of the first instance of the province or city where he held office of the time of the commission of the offense, or where the libelous article is printed and first published, and in a case of one of the offended parties is in a private individual, the action shall be filed in the court of first instance of the province or city where he actually resides at the time of the commission of the offense, or where the libelous matter is printed and first published, provided further that the civil action shall be filed in the same court where the criminal action is filed and vice versa, provided furthermore that the court where the criminal action or civil action for damages is first filed shall acquire jurisdiction to the exclusion of the other courts, and provided, finally, that this amendment shall not apply to cases of written defamation, the civil and or criminal actions for which have been filed in court at the time of the effectively of this law. Preliminary investigation of criminal action for written defamation as provided for in this chapter shall be conducted by the provincial or city fiscal of the province or city, or by the municipal court of the city or capital of the province where such action may be instituted in accordance with the provision of this article. No criminal action for defamation which consists in the imputation of a crime which cannot be prosecuted. The official shall be brought except at the instance of and upon complaint expressly filed by the offended party, as amended by Republic Act Number 1289, June 15, 1955, and Republic Act Number 4363, June 19, 1965. Article 361. Proof of the truth. In every criminal prosecution for a libel, the truth may be given in evidence to the court, and if it appears that the matter charged as libelous is true, and moreover that it was published with good motives and for justifiable ends, the defendant shall be acquitted. Proof of the truth of an imputation of an act or omission not constituting a crime shall not be admitted, unless the imputation shall have been made against government employees with respect to facts related to the discharge of their duties. In such cases, if the defendant proves the truth of the imputation made by him, he shall be acquitted. Article 362. Libelous remarks. Libelous remarks are comments connected with the matter privileged under the provisions of Article 354, if made with malice, shall not exempt the author thereof, nor the editor or managing editor of a newspaper from criminal liability. And that's all for today's guys. I hope you'll learn a little. And if you like this video, please like, subscribe. Feel free to comment down below if you want answers, suggestions, or opinions regarding on my current video. And that's all for today. I hope all is well with you and your family. And good luck to your life. God bless.